We're live.
Okay, well, good morning. Good morning, committee. For the record, Rebecca Turner from the Office of the Defender General here to speak this morning on S4, but I understand I'm here specifically to focus on the sections of the bill related to firearms. So some of you have heard me testify before, but to just provide a little more of an introduction to who I am and what I do as a Defender General, I am head of the appellate division there, and as my job, I review closely controlling constitutional law, including controlling precedent from the United States Supreme Court, because I have a duty to provide, to uphold the Constitution, consistent with my representation of clients and my obligations to provide competent representation. So here I wanted to share, before I dove into the specific sections of the bill, sort of my understanding of the watershed decision that came out of the United States Supreme Court, and that's the New York State Rifle Pistol Association v. Bruin, referenced here Bruin first one today. And I understand you have other witnesses to provide some background, but I think it's impossible for me to dive into S4 without sort of laying what I understand Bruin has done for us in this landscape. So again, coming from the perspective of how I understand the Constitution, specifically the rights and analysis that are intended to, that's protected in the Second Amendment. So we've heard a lot about that. This is a watershed decision. Right? From my perspective, it is watershed because it fundamentally resets the constitutional analysis for me as a constitutional attorney in three fundamental ways. First, it confirms clearly that the old analysis is thrown out. The old analysis that has come to be applied upon in this circuit and other circuits, which is that when reviewing a challenge regulation, there was a means scrutiny analysis, which was deferential to governmental interests, the motivation behind it. Instead, what we now have clear direction from the U.S. Supreme Court in Bruin that the correct analysis is in fact rooted in the text and history of the amendment. Text and history now control. If the plain text of the Second Amendment covers certain conduct, then the Constitution presumptively protects that conduct. So the third most fundamental principle that comes out of that is sort of a natural extension of that. If the regulation protects this protected conduct, the regulation is now presumptively unconstitutional. So that is a fundamental switch, again, as a constitutional attorney, where there are certain attached presumptions of constitutional that extend to legislative matters. Right? Here, when Bruin, we now have that if it falls within the conduct protected by the Second Amendment, the plain text, the definition of arms, right? The right of the people to keep and bear arms, if it falls within that, then the regulation is presumptively unconstitutional. The government has the burden to prove that, right? That it is otherwise not. And that second step is where there is a new analysis, and where the step one, the definition and meaning of arms, the definition and meaning of people, right? That is an analysis that existed before Bruin. The new analysis is the second part. What must the government prove to establish that this regulation is in fact not presumptively unconstitutional? And that is that they must show that there is a historical tradition regulating the same conduct. Historical tradition regulating the same conduct. Historical tradition is now being teased out by the courts, and after Bruin, what is the meaning of historical tradition? Well, we have some guidance from Justice Thomas in the Bruin decision. And here are the quotes that Justice Thomas provides. must identify a well-established and representative historical analog. Identify a well-established representative historical analog. And so that means there are outliers on and off, right? And what is the relevant period of time? We also know from Bruin that it is at the time that the ratification of the Second Amendment occurs, 1791. Any indication of historical laws that are further away from that time frame become significantly less relevant. The Supreme Court is pointed to, we need to know what the Supreme Court had in mind. And so it's not enough to show outliers. There has to be historical laws common and prevalent at the time. And while the Supreme Court was clear, it doesn't have to be an identical twin, right, to the current challenge regulation. It has to be analogous in two important ways, both in similar in how the law operates, right, and why the regulation is burdening this protected conduct. So now courts are directed to look at what this state is presenting as evidence of this historical tradition, right? That's regulating similar, that similarly regulates the conduct that is challenged. And so this is where there is so much activity going on, so much ink being spilled, right? Both by the parties litigating this, the decisions that we're now seeing in lieu of Bruin, the scholarly articles that are now being produced on this. This is the unknown that we're operating. So I just want to give that back up to Bruin before now. This is how I understand it. It is both very clear of what is not the continuing analysis. It is very clear as to who has the burden and what must be shown, right? How much, what it is, that's all being pointed out. But I wanted to share some of the specific decisions that have come out directly on point to sections of S4. So I wanted to start in on section 4. Section 4 of S4. That is concerning defacing firearms serial numbers. Defacing of firearms serial numbers, page 5, right? So this is being established as a felony, 5 years. What's useful about this proposed language is that it mirrors in substantive effect, federal statute, right? 18 U.S.C. 922. Actually, 922 section K. And so what's useful about where the courts are landing post-Bruin on this specific language is that we know that at least one federal district court has struck this down as facially unconstitutional post-Bruin. Now, other courts have reviewed the same and have upheld it, right? But what I want to share today is the analysis and make sure that it's on your radar that it's the Southern District of West Virginia in People v. Price, October 12th, 2022. Went through and determined that the conduct being regulated here falls within the definition of the Second Amendment, falls within the protected arms. So then the court moved to the second part. Since it is presumptively unconstitutional, did the state meet its burden of showing a historical analog? And that's where the judge found the evidence lacking, right?
Rebecca, I'm sorry. Did I understand you correctly to say that one struck it down, but more than one have upheld it?
I don't know how many. I just know I'm focusing on one, and
I think it's important if we know that the majority of courts upheld.
I can't answer that.
I thought you said that several courts have upheld.
I know that I did make a mention that I think that it has been upheld at least by one other judge recently, and I can't. And
I have those two. I have two.
oh, thank you, Eric.
Two?
Yeah, so two
So two have upheld?
I don't know that that's an exhaustive list. The three that I know of are the one that Attorney Turner mentioned from the Southern District of West Virginia that struck it down. The two that upheld it were one from the Northern District of Texas and one from.
Right. I guess my point is just to make it clear that it still seems to be a minority opinion that it was struck down.
I think that I would hesitate by qualifying anything as minority, majority, and certainly to put any weight, even if you could, that's minority or majority. Here's what I think is going on. There is a huge sort of resistance, I think, understanding fully of what happened with Bruin. And again, coming at it from constitutional attorney perspective, this is a fundamental shift. And getting attorneys or judges to accept that now the government's interests, policy interests, in these type of regulations is no longer part of the equation, right? This is the law, right? So what we have to point to are historical analogs or the meaning of arms. So as I understand what Bruin establishes on that first piece is the regulated conduct falling within the plain text of the meaning Second Amendment. We're not in very new territory there because that is a natural extension from the case law in Heller and right. And what we know is that it is pretty broadly defined in common use, right? For lawful purposes by the people. That is the definition. It is not turning on what the government has determined to be dangerous, right? And has defined. It's looking to, again, law-abiding people in America who are using these guns. And what is the meaning of common use? Though that's where the litigation lines the bright lines haven't been established. But Heller, the decision of Heller considered the handgun at issue there, considered the numerosity of the handguns there, and determined that was in common use. Judges elsewhere have at least used those numbers of how many were prevalent in the United States, right? They're looking at common use, not just in the particular jurisdiction, they're looking nationally. So when we analyze these definition of firearms here, we're not looking at how many of these particular weapons exist here in Vermont, right? It's the entire country. And that has been at least one safe number that people turn to. Is it comparable to the numbers of handguns identified at the time? The definition of common use, also Bruin and Heller have established. Definition of arms isn't locked into the 1791 period, right? This gets a little confusing. It is adaptive and accommodating to modern weapons that didn't exist at the time.
Well, and that's where I have a real lack of comprehension of the logic. Because if we're saying that the guiding principle is historical tradition for people who want to regulate firearms, but then we're saying for people who don't want to regulate firearms, anything that wasn't in common use can be invented today and still be covered by the traditional definition. So on the one side, invention, innovation in terms of lethal power is not an issue. It still partakes of the historical tradition. But on the regulatory side, if it wasn't regulated, in the 18th century, then we're bound today by that. So on the one side is allowed to escape the historical tradition in terms of having the Second Amendment cover whatever kinds of weapons they want. The other side is purely limited. So if I could just bring it back to defacing the serial number, what is the logic for striking down? Is it that we are not allowed to put a serial number on a gun, or we're not allowed to criminalize taking the serial number off the gun?
I think that under the Second Amendment, under Bruin, the analysis has been this. The firearm that is identified here falls within the definition of arms, right? So that's protected. The judge determined in the West Virginia case looking for, well, where's the historical analog that at the time 1791 and leading up to it, there was a concern to track these equivalent arms, right? Track arms in any sense, and the how and the why. Like, where was there a requirement to put numbers or otherwise register these weapons, right? And or is there an equivalent to that? And was it for the purpose? This is the why, the how and why. Why was that done? Was it because there was a concern that these unidentified, untracked firearms were being used for violence or whatever? You know, again, what is a similar motivation here as to what these laws are doing? What is it trying to achieve? And so this is where the judge said, we can't find, you know, the government produced, I think, this is where the details get blurred, but the bottom line was that there was not a sufficient evidence to establish that this was, again, not just one or two, but it was just a tradition of this, that the serial numbers weren't there. So that's where it came away. Yeah.
So in other words, if I'm reading you correctly, then what you're saying is that it's indefensible to have a serial number on a weapon.
Under the Second Amendment, well, I don't know about that. This is about criminalizing the removal of it, right? So
If
this
it's
is
legal to
different,
have a serial number,
right?
why would it be illegal to remove the serial number? Or why would it be legal to remove the serial number?
So, and I understand your questions, right? I think what you're getting into, or the nuances and the details, it's to proper scope of regulating firearms, right? Here, though, what this is doing, and let's look at this language. It is establishing an absolute prohibition. It's a ban of possessing a firearm, right? And so so the protected conduct under Bruin is that you can possess arms, right? So is the definition of the firearm here falling within the Second Amendment?
But this is not banning the firearm, it's banning a firearm that's had the serial number removed.
And so the question then is how, you know, I think one of the questions that comes out of Bruin, but I think we have the case law before Bruin on this question is, what is the scope of the definition of arms? Right? Is it arms with or without serial numbers, right? But that has not been, there hasn't been, that I remember, controlling precedent. Heller didn't get to that level of granularity in terms of defining firearms. But so that is a problem for that section. Outside the Second Amendment, and I don't think it's been raised yet, lines 8 and 9 of that section is going to using this conduct that constitutes the offense of defacing a firearm serial number shall be considered a violent act for purposes of determining bail. I want to make sure it is on this committee's radar that, and not talking about the Second Amendment. This is a concern for our Vermont Constitution and specifically our bail provisions. But linking up and using the word violent act for purposes of bail. Violence in our bail constitutional scheme has constitutional meaning, right? So bail can only be imposed under the Vermont Constitution for the purposes of ensuring against flight from prosecution. That is a constitutionally established requirement. Right? The limitation on imposing bail. Here, what I read 8 and 9 is doing is actually now expanding the situations where bail can be imposed, right? Expanding what constitutes violent act.
Rebecca, I wanted to get your opinion. You know, one thing we had discussed, I can't remember if it was yesterday or the day before, but you know, regarding this particular section and another section that mirrors the same language, which you know shall be considered a violent act for the purposes of determining bail.
Yeah.
The change that I believe we discussed was making it so that the conduct is considered a violent act for the purposes of determining whether or not someone will be held without bail. Does that change?
It certainly changes my point because now what you're talking about and I have to see the proposed language specifically, but you're referencing the two provisions, the whole without bail provisions and acts involving crimes of violence, where that presumption to release is different. But I just would have to read what the proposal is.
I don't think we have official
Okay,
language yet,
okay.
but it was something we discussed because I believe the point that you brought up was also brought up in another conversation,
Okay,
and we
great.
came up with that idea.
Okay. Okay, great. Section 5. I can move on to section 5. Any more questions in section 4? Okay. Section 5 is the straw purchasing of firearms. So again, before I get into the Second Amendment discussion, here I just wanted to flag concerns of sort of fundamental due process problems. I mean, this comes in whenever you have crimes establishing crimes based on third party. Someone who isn't actually doing the actual criminal act, but here is purchasing on behalf of another person. And here we don't even, the statute as written or the bill as written doesn't have the mens rea of even knowing that the other person is, and that is the person you're trying to prevent from having
Isn't
the
it,
firearm.
if the purchaser knows or reasonably should know?
Right, reasonably should know is not knowing. Like it's effectively like a strict liability offense. Reasonably should have known, an objective assessment, not the subjective inquiry. So you've got, is this a felony? I think it is. Yeah, 5-year felony based on a strict liability. That is contrary to fundamental notions of due process and criminal law. So just wanted to flag that as a problem. In terms of the second.
Can I just comment briefly or a question?
Sure.
That's copied, I believe, from federal law, and I think it's less of a penalty than federal. So if there's a problem with it, then I would expect that the federal law would be challenged as well.
Well, I can't, so here's, I don't know where to look, but good morning, Gary, I don't know if it looks like I'm looking to, but I would just say that the due process concerns would also separately raise Vermont constitutional concerns, and I don't know of the federal case law reviewing the federal analog of that right now to sort of respond, and I'm happy to come back another time to dive deeper into the mens rea issues there. But I hear your point. But there would be also just a separate Vermont constitutional analysis that should be done. And of course, Article 10 covering due process
Okay,
has been interpreted as going further. But I'll leave that as
thank you.
that for now. So Section 5, straw purchasing. On the Second Amendment front, again, the text of the Second Amendment, the right to keep and bear arms, has been interpreted by the courts to include sort of ancillary rights attendant to make the right actually real, right? So that means, and has been interpreted by the Ninth Circuit 2022 in Jones v. Jones Act. And I can provide the citations to Eric for reference, but that has been determined as including the right to keep and bear arms includes the right to purchase them, right? So again, this question of does this on its face fall within the text of what is protected under the Second Amendment? I think that it would be. And so I wanted to flag to this committee, then you're now in step 2 under the Bruin analysis, which is presumptively unconstitutional, burden on the state, provide the historical analog. Right? I am not aware of any courts at any level post-Bruin analyzing these straw purchasing equivalents in a fine form. But I just wanted to share at least that it would be in that judgment.
Am I understanding you correctly to say that you think the ability of the state to require a background check and prohibit someone from buying based on that is potentially unconstitutional?
Yes, well, it's presumptively unconstitutional. The question I think you're asking is, is would I have concern of the state's ability to find historically relevant evidence to overcome that presumptive unconstitutionality? Meaning, can they find a historical analog at the relevant time that's not an outlier? I have concerns, although again, I haven't done an exhaustive deep dive of the history around this, right? And that's what's going on. And the parties are litigating this and bringing forth their experts to bring this forward. The courts are diving into this as well. I believe your witness next has the Duke University website is starting to compile these historical laws. So I'm doubtful that they could find it based on the Bruin,
Well,
beneficent.
and my, I've said this before in other ways, and I'll say it again. If the practical effect of the Bruin decision is that we're in a society where we can't have serial numbers on guns, where we can't prevent people from buying guns who shouldn't have them. Everyone is allowed to conceal carry. Everyone is allowed to openly carry. Then we're clearly headed for a society where the current level of public and mass shootings is just a taste of where we're headed. And I think it's a collectively insane project. And I feel as though it cuts against common sense in every way that we can think about, to be looking back to the 1780s for direction about how to make our people safe today in a world where guns are so out of control. So I appreciate what you're saying. I don't know that I believe federal appeals courts, for instance, or the Supreme Court even, are going to wipe out background checks and serial numbers. You're cautioning us in those areas, but I think Senator Sears is right. I can't imagine the federal law being struck down as unconstitutional that prohibits people from defacing serial numbers. Not to mention straw purchasing, which is just openly evading the law and putting guns in the hands of people who have been very painstakingly prohibited from having them. So I appreciate your analysis, but it's outlining a view of lawmaking in the world that I can't accept. So
I understand, and I hear you. Senator, I just wanted to restate what I see my role here today is sharing with you how I am reading these decisions as a constitutional attorney, and how I understand the analysis to be, and what is now the state's burden to prove, and what the committee should understand to expect as a very real consequence if this legislation is passed, right? Which is that there will be litigation. And if not here in Vermont precisely, because the precise case is not happening quickly, right? It will be happening elsewhere around the country. And what I am just highlighting are examples of courts striking them down now, right, elsewhere. And so it is just a reality to know that the consequences, that there is not going to be, I think, any surety or stability in this area, and knowing that these laws will hold, and the cost of litigation, in the full meaning of that word, in terms of that. The other, and again, I'm not here to weigh in on the broader policy impacts of this decision, or to suggest other avenues to work in. But again, I want to just make sure that at least this is on your radar as to what is the consequence of passing this, which is that it will be litigation. It will just be litigation. Whichever party uses it will be appealing.
For the parts of the bill that are analogous to federal law that is already in existence, are those being challenged in the U.S. Supreme Court?
Yes, are you talking about 18922?
I don't know the
Oh, sure.
federal
Yeah,
code,
yeah.
but I know that there's multiple points in this bill that are in fact simply copying the current federal law.
they are working their way up quickly to the US Supreme Court. I don't know of any pending cert petitions right now that the US Supreme Court could be on the verge of accepting, right? And in fact, if I can move on to section 6, which is, what is the title here?
Fugitives from justice.
I can talk about just yesterday, the Fifth Circuit Court of Appeals struck down the federal equivalent, finding it facially unconstitutional under the Second Amendment. Let me find my page. This is page, yes, page 7. And so that decision is Rahimi, United States v. Rahimi, Fifth Circuit panel of judges issued a decision yesterday. I think even before the end of the day, the Department of Justice indicated it intended to appeal that decision. And in United States v. Rahimi, they reviewed the federal analog 18 U.S.C. 922 G8, which is categorically prohibiting people from possessing a firearm who are subject to relief from abuse protective orders. Now, earlier last year, post-Ruin, there was a federal district court in Texas who struck that specific subsection down. Again, finding that the regulated conduct fell within the plain text of the Second Amendment, moving to the second step, whether the state could meet its burden of showing a historical analog. That federal district court judge in Texas found that there was no federal analog at the time. Here, the Fifth Circuit, reviewing this late last night, when it landed on my radar ahead of in preparation for testimony, that panel of federal circuit court judges determined it also fell within the definition of arms, and that the people, right, the text, the Second Amendment concerned the people have the right to bear arms. So there, the government challenged that people who have been found, who have been issued these, have been subject to protective orders, right? Who, at least on these court orders, have been deemed not responsible, right? Not law-abiding. The government argued that those people were not the people as contemplated in the term and as used in the context of the people, right? People doesn't include law-abiding. People doesn't include the responsible. So therefore, the Second Amendment did not, on its face, protect this conduct. That was the argument.
But Second Amendment doesn't have people in it, does it?
It does.
Does it?
It does, yes. So the right of the people to keep and bear arms. And so what the Fifth Circuit did in response to this argument from the government that the people necessarily exclude certain people, right? They went through and they looked at where the Bill of Rights elsewhere uses the term people. And they found that the people is also used in the First Amendment. It's used in the 10th Amendment. It's used in the Fourth Amendment. And so then they drew upon case law from the US Supreme Court interpreting the people and where those rights are extended. And so this will be relevant when we get to the Section 8 related to age, right? But they found that the people does not exclude based on lawful or unlawful.
I just want to caution that we have a very tight agenda this morning.
Excuse me, sorry, Mr. Chair.
Yeah, and I'm concerned that we have a professor from Duke University up next, and then we have the mayor of Burlington, and I don't want to get too far out of sync here with the agenda. But please go ahead.
Senator Sears, just want you to know, Mayor Weinberger's drove down from Burlington. He's here. I don't know if you want to try arranging the schedule. Professor Miller is on Zoom. If you have
Yeah, I know. He's got little, he may be on a timeline too, so we're going to do our best to hear from all three witnesses this morning. Just wondering if we can, Peggy and I and you had put together a half an hour where Rebecca and I know we get started a little bit late and I was late joining. So, but I just want to caution us that I want to hear from all three this morning.
Understand, if I could just have 5 more minutes to wrap up.
Oh, yeah,
If
absolutely,
the committee wants to have me back to go into deeper.
absolutely.
I'm happy to come back. But back to section 6 and what the Fifth Circuit did was really look to these other cases interpreting the meaning of people, and relevant also for the section 8, where you are targeting and addressing limiting possession of semi-automatic weapons for persons under 21. This is also relevant there. The First Amendment has been held to extend to children, right? We know that case haunting, or it's the circumstances where speech may be limited, right? So in school, so we have this case law. So drawing from that, there have been, again, cases where the, let's see, which is the, I don't have the, there's the children's. There are cases where they have struck down the attempt by the government to argue that people excludes the class of people that the regulations are targeting. Because, so then it goes back to step 2, back to the state's burden to prove this historical analog. And again, United States v. Rahimi and United States v. Perez-Galvin found in the Fugitives from Justice section 6 that was facially unconstitutional and overthrown. Categorical prohibition when a person has been charged with a felony is another aspect of section 6, again mirroring the federal analog of 922, this time 922 section N. This is 18 U.S.C. 922 subsection N. And another federal district judge, United States v. Juarez, in September struck that subsection of the federal statute down on facial, unconstitutional grounds under the Second Amendment, under Bruin, again finding that the state had failed to meet its burden. So I think I will honor the chair's request that I be speedy, and if there are no other questions, I'll stop here. And again, I am happy to come back.
I think it would be great if the chair is up for it to have you back to also talk about section 8, which I don't think we were able to cover, which is the possession of semi-automatic assault weapons by persons under 21. If the chair would like that.
I'm happy to do that. It certainly warrants it. There was a separate federal district court decision addressing a similarly analogous prohibition relating to age that struck that down on Bruin.
I think that would be helpful if we could have a discussion solely on section 8, and with you and anybody, and I think we'll have others next week. So hopefully we can fit it in next week if you're available. I appreciate your willingness to come back to talk about section 8.
No, thank you. Take care.
Mr. Vice Chair, if you'd take over, please.
Sure. Professor
Because
Miller,
I can't see Professor Miller.
Professor Miller. Okay. So the professor is fine with you going first, Mayor, because you drove down from Burlington, and I know we're on a time crunch, so I just want to make sure we're respectful of your time and Professor Miller's time too. So.
Great, I appreciate it. Thank the Judiciary Committee for having me here. Thank you to the chair. I think it's been some years since I've testified in front of you. I very much welcome the.
I'm sorry, I'm in the warm area in Bennington here. We're not even below 0 yet. So.
Well, I think it's coming, Senator. It's.
It is.
I initially thought I was not going to be able to join you because I was supposed to be in the Adirondacks backcountry, but when we saw the -66 projections, we reconsidered that trip.
It's a good day to stay inside.
I'm really very appreciative that the committee is looking at S4 and probing deeply into these issues. As you've all seen, Burlington is in its fourth year now of facing a very uncharacteristic spike in gun violence. And we are acting on many fronts. And I think that the way to turn this around takes a lot of work at the local level, at the enforcement level, at the level of partnering with various youth-serving organizations and other organizations in the city. I do think we need help with this, however, and I do think legislative action is part of the getting us back to the level, much reduced level of gun violence in Burlington and elsewhere in the state in the years ahead. There are two areas in particular of the bill, as I read it, that I wanted to comment on. And I understand you're tight on time, so I'm going to dive right in. The first section was the first section of the bill that would require that proceedings against persons 14 to 21 years of age originate in the criminal division of the Superior Court if the person is charged with human trafficking, trafficking a regulated drug, or carrying 12 dangerous. Run over there, carrying a dangerous weapon while committing a felony. This seems very much on point with some of the conversations that we've been having with our police department, with the state's attorney. We are concerned. We think really examining the interaction between family court and gun violence is important. From our vantage point, we're limited in the information that we can see about that relationship. We do, however, believe that there were missed opportunities in recent years to interdict, to stop escalating gun violence between various members of the community, potentially because of that interaction with family court and the way in which that activity that goes into the family court is shielded from other areas of law enforcement and frankly shielded from us and others being able to act in response to crimes that get handled in that manner. And so this strikes us as wise to give a judge the discretion by originating in the Superior Court as to whether it makes which way to go, and whether the seriousness of the crime is such that it should stay with the criminal division. The one comment that we would make on this is we'd ask you to consider going even a little bit further with this direction. And this ties into something that the state's attorney, Sarah George, has said, our chief has said, and there's a little bit of kind of public discussion about it. Vermont, reckless endangerment with a gun, shooting up bullets in the city, in and of itself does not constitute a felony right now. And we think it should. Other states, our neighbors, do have it that way. New York and New Hampshire both have felony level charges for that kind of reckless endangerment. As we read Section 1 now, this would, in some circumstances, sort of address the concern we have, but there would still be some gaps. And I do want to, there's sort of three, I think, interesting examples that seem relevant to me about this and that you might want to probe in further if you agree. Each of these are examples of where we had reckless endangerment with a gun in the last few years, and we were not able to pursue kind of felony level charges. One was this very high profile, you've probably seen video of it, the shootout that took place at a gas station in Burlington, a three-way shootout. A bystander was almost, was pretty near to some of this activity. Could have been hit, wasn't fortunately, but could have been. No one was hit. And at least at the point at which the Burlington Police Department's involvement with this case ended, it was not possible to charge anyone with a felony. That might sound surprising in that, people were shooting at each other. You would think that might pull into play attempted murder, other serious charges that are felony charges. But the way this actually plays out in the field, in the real world, often we have difficulty working with the potential victims in a situation, or the actual victims in a situation like this. We frequently struggle to get cooperation from them, and so the ability to be able to bring to the state's attorney an attempted murder charge in a situation like that is compromised by the lack of cooperation and no one being willing, being willing to sort of confirm I was being shot at and this is a more serious crime. So to have the possibility of a reckless endangerment crime requires much less in terms of kind of cooperating victims, and maybe would give the police and prosecution an additional tool. A couple more quick examples that are similar, just because I think you are right in thinking that this gun violence spike could be impacted by legislation. We had a situation last summer, you may recall, in City Hall Park, where there was an individual who shot off 2, maybe 3 rounds in City Hall Park. Seemed to be somehow maybe drug transaction related. No one was hit, but again, it was daylight hours in City Hall Park. Certainly, you could have had bystanders hit. The police moved quickly on this. Actually got a search warrant and searched the individual's home. I think the incident happened on a Tuesday or Wednesday. By Friday, they were in the person's home. They were unable to pull together enough to bring charges immediately. And on Sunday of that same week, that's the same individual committed a double homicide. I think it is possible that that having this, again, we're a situation there where we were not yet able to kind of bring a clear attempted murder charge. It is possible that this additional charge could have impacted how that played out and maybe even had an impact on that outcome. Finally, we had another scary incident on Church Street where there was an individual who was just in a menacing way walking around, wielding a gun, threatening people, not initially discharging them, but eventually he did discharge the guns, and it was quite a scary situation. And again, I think alarming to me, concerning to me to hear that there was no kind of felony level charge for what seemed like a very serious activity in the city. That's what I had to say on section 1. I did just want to speak directly to. Sorry, happy to pause.
No worries. How old were the people in instances you outlined?
With the gas station related shootout, these were juvenile individuals that were less than 21 years of age, is my understanding.
Okay, but in the other instances, that was not
the other instances that I don't believe they were. I think both of those, certainly the double homicide individual was older. I'm not sure about the age of the third example I gave. And so that may be, in those 2 examples, they may be less relevant to this idea that you're going to capture 14 to 21-year-olds than the sort of broader point that I think would be on point with this bill to consider adding this reckless endangerment charge.
Thank you.
I wanted to briefly comment on the 9th and final version as well, the establishing of a grant program to permit communities suffering from an increase in violence to possibly receive financial assistance. This would be very well received in Burlington. You may hopefully have seen that, beyond the law enforcement efforts that we've been pursuing actively and that Burlington Police Department should be commended on, that over 80% of the individuals who've been involved in not the gunfire incidents, but the shootings where someone was actually hit or worse. In over 80% of those crimes, we have arrested the shooter. The we want to go beyond just a kind of law enforcement response to this. So I've set up a task force being led by our Director of Racial Equity, Inclusion, and Belonging that is really trying to involve many different stakeholders in the community for a conversation about, is there more youth serving organizations could have done, could be doing going forward to prevent this type of violence? Is there more the business community, more the faith community could be doing? It's really kind of a broad examination of interventions that we could be considering. And I could see a range of different interventions coming out of this that could really benefit from state financial assistance. So appreciate that is in there and called out that way. Yes.
Quick question. So on page 13, that grant program that you were just mentioning is laid out. It says, so it's establish a process for a community where there has been an increase in violence associated with illegal drug use, gang activity, or human trafficking. There has been from at least one other witness a suggestion of eliminating that more specific language and just having it be an increase in violence, regardless of whether it's connected to human trafficking or drug use. Thoughts on from your perspective, which might be better?
We reviewed that language and thought it certainly captured what we've experienced. So I think, as I would think important, even the broader one obviously would as well. I think it really then comes down to. It's hard for me to answer that question from my perspective. It depends, I think, from a state. I don't have that statewide vantage point as to how important it is to focus resources, or whether there's enough communities that are struggling that I guess my sense is that this has been a pretty broad increase in gun violence across the state, and I certainly hear when we talk to the state police and try to get their support with what we're facing, we hear that kind of the state is on fire in lots of other areas too. Burlington gets a lot of the attention given the kind of media environment, but that we're far from the only place that is really struggling. So given that, it might be wise to have a pretty broad definition and make sure that any community that can kind of galvanize a response to this can get some kind of support, not so far too high.
Thank you.
If there is I'm happy to answer more questions, of course. And then I feel like I'd be remiss in not articulating, and I don't want to stray too far from what you are directly already considering. I do hope that this committee remembers the long tradition the people of Burlington have had of wanting further legislative action on specific gun violence related issues. Specifically, we had charter changes back in 2013 that never got off the wall, and the government relations committees here, I think there's only one hearing ever held on it that would have put safe storage requirements for guns in Burlington, and that would have prohibited guns in bars and restaurants. Both of those two issues, looking back on it now, were prescient to be for Burlingtonians to be concerned about them. In this recent spike in violence, we saw about 25% of that take place as bar-related late-night activity. We saw 6 of the 17 last crime guns that our police have recovered were stolen guns, some in very concerning, very unsafe locations, front seats of cars. I take this bill to be an effort to address the emerging violence we are facing today. Given that, I'd ask you to consider whether, with those those statistics, that this is a nexus that might weigh in favor of bringing those issues in as well. No longer asking for charter change on that. Personally, I should have sense that is not the direction the legislature want to go. So given that, I would ask for that to be considered a statewide legislation.
Mayor, we have one question, Senator Norris, and then we have to switch gears.
Okay.
Yeah, just a quick question.
Yes.
Burlington being as large as whatever else, I'm surprised you didn't bring up sections 2 or 3, and I'm curious as to what Burlington may be facing with landlord problems as far as human trafficking and/or the use of illegal drugs and so on and so forth. What are you seeing in Burlington in reference to that?
So we certainly are very concerned about the the fentanyl epidemic is terrible, and we are seeing there's been an enormous increase in trafficking with the related community impacts of that.
Has your police department indicated this is a problem, Eric?
Yeah, we have not had problems with landlords that I'm aware of, but I will definitely circle back with them and make sure if there's any specific examples of Burlington that would be helpful for this. I'm not aware of them right now, but I appreciate that you're looking at this and we'll follow up with that.
Okay, thank you.
I have one quick question. But Mr. Mayor, thank you for being here. What we've seen in Bennington is gang activity from other states coming here and particularly using young offenders. I wonder if you've seen any gang activity, out-of-state gang activity in Burlington or Chittenden County.
Thank you, Senator. Yes, we have had a group associated with kind of an organized crime entity in Philadelphia that has been operating in Burlington at times. And one of the scarier incidents of the last year, really one of the worst, this just sort of a blatant homicide in City Hall Park where someone sitting on a park bench was shot in the back of the head. That is the person who was arrested was a resident of Philadelphia and was definitely operating as part of a link between activities here in Burlington and crime elements in that city.
Yeah.
So we do have
Actually, you're probably using a better term than I did, as gang is more organized crime. And certainly,
well, thanks for saying. I mean, we do sort of make a distinction there. It's not clear. Yeah, in the sort of historic way we've thought of gangs, this group may be a little bit different than that. The chief could provide more detail on that if that was helpful.
I appreciate your comments. Thank you.
Thank you very much. I appreciate it. Happy to come back as you get deeper in this. That'd be helpful.
Did you want me to go ahead and begin?
Senator Sears.
Hope you're muted.
I'm trying to mute myself. Yes, please. And thank you for your patience and appreciate your being here today.
I'm happy to be here. And thanks for the invitation. So Chairman Sears, Vice Chairman Hashim, and distinguished members of the committee, I appreciate the opportunity to testify today. I'm Daryl A.H. Miller. I'm the Melvin G. Shim Professor of Law at Duke Law School, faculty co-director of the Duke Center for Firearms Law. I'm providing this testimony today in my personal capacity. So I understand this committee is considering legislation that touches on matters related to firearms and gun violence prevention, and that you seek information about the past, present, and future of the federal Second Amendment with focus on the meaning and effect of the U.S. Supreme Court's June 2022 decision in New York State Rifle and Pistol Association versus Bruin. My conclusions are as follows. First, Bruin, properly applied, leaves ample room for regulation to promote safety and gun violence prevention. Second, Bruin has and will generate considerable short to medium-term legal uncertainty until such time as appellate courts converge on an administrable test for the Second Amendment and or the United States Supreme Court clarifies the test for deciding Second Amendment cases. Third, historical sources, information, and expertise will be more important than ever in justifying the constitutionality of regulations in the nation's courts. And fourth, empirical data on firearms policy remains relevant, but will need to be translated into a historical frame for litigants and judges to evaluate whether the regulations are compliant with Second Amendment limits. So let me elaborate. The Second Amendment is pretty short. It reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, for 200 years, every federal case to consider this amendment held it did not confer an individual right to keep and possess firearms unrelated to membership in a well-regulated militia. State constitutions may have conferred greater rights, but the Second Amendment was largely inert as a matter of law. That changed dramatically in 2008 in a Supreme Court case called District of Columbia versus Heller. Heller concerned a challenge to a regulation in DC that made it practically impossible to keep a functional handgun in the home for purposes of self-defense. Dick Heller was a district resident, sued the city, and claimed that this regulation violated his Second Amendment rights. The Supreme Court, in a 5-4 decision written by Justice Antonin Scalia, agreed, holding for the first time that the Second Amendment guaranteed a right to possess firearms in the home for personal purposes unrelated to membership in an organized militia like the National Guard. That said, the Heller majority was clear that the Second Amendment, like all constitutional rights, is not absolute. Nothing in our opinion, Justice Scalia wrote, should be taken to cast doubt on longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. The court also said that only weapons in common use enjoy constitutional protection. Weapons that are dangerous and unusual can be regulated or prohibited. Heller addressed only the District of Columbia regulation on firearms in the home and left a host of questions unanswered. Does the Second Amendment right extend beyond the home? Who are the people protected by the Second Amendment? Does the people include undocumented immigrants or minors? What qualifies as a weapon in common use as opposed to dangerous and unusual? To answer these questions, lower courts fashioned a two-part framework based on the language of Heller and a doctrinal approach used to implement the First Amendment. At step one, courts examined whether the firearm-related activity fell within the Second Amendment scope or if it was categorically excluded. The second step of the test looked to the stated purpose of the regulation, how well the regulation accomplished that purpose, and how much otherwise protected activity would be affected by it. So, for example, for prohibitions on devices like fully automatic rifles, courts would say that they were categorically excluded from the Second Amendment coverage because they were dangerous and unusual and stop there. For prohibitions on firearms with obliterated serial numbers, the court first asked whether firearms with obliterated serial numbers were categorically excluded, according to Heller. If they were not, the court then would examine the stated goal of the prohibition, typically crime detection and prevention, the effectiveness of that regulation in accomplishing the goal, and the effect of the regulation on otherwise protected activity. In the case of prohibitions on guns with obliterated serial numbers, the courts upheld these regulations because crime detection and prevention is obviously an important government interest. It was a logical way to pursue that goal, and the prohibition did not sweep in too much protected activity because it was still possible to defend one's home with a firearm that had a serial number. So every appellate court to directly address the issue used this two-part framework for the Second Amendment cases for the next 14 years, and that's what changed in 2022. In New York State Rifle and Pistol Association, the court upended this settled lower court precedent in a 6-3 majority opinion written by Justice Clarence Thomas. Bruin had to do with a New York discretionary licensing permit regulation to carry a pistol. At issue was whether the Second Amendment right to bear arms extended beyond the home. The court held it did. The court also held that the discretionary may issue licensing law of New York and 5 other states violated the Second Amendment. But the major change that Bruin inaugurated was to reject the two-part framework lower courts had been using and to replace it with a new text, history, and tradition framework. From now on, the constitutionality of gun laws depends on whether they are, in some yet ill-defined sense, consistent with this nation's tradition of firearm regulation. This new text, history, and tradition approach itself appears composed of 2 parts. The first step of this new framework asks whether the Second Amendment's plain text covers an individual's conduct. Now, elsewhere, the majority says that the first part of the test is text as informed by history. If the text, or the text as informed by history, covers the conduct that the Constitution presumptively protects that conduct, the burden then shifts to the government to justify its regulation in step 2. At step 2, the government may not simply posit that the regulation promotes an important government interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Of course, there will be numerous regulations that don't have precise historical parallels. There are societal problems or technologies completely unknown in the 1700s when the Second Amendment was ratified. For these circumstances, courts can apply a, quote, nuanced approach and rely upon analogous historical regulations. The historical regulation need not be a historical twin, but must be a well-established and representative historical analog. In order to provide that in order to prove that the contemporary regulation fits within an American tradition of firearm regulation. The mechanics of this analogical process are still being worked out in the lower courts, but Bruin instructs that they would be guided by how and why the regulations burden a law-abiding citizen's right to armed self-defense. 3 justices wrote concurrences, but one written by Justice Brett Kavanaugh, joined by Chief Justice John Roberts, is especially noteworthy. And I will say it's especially noteworthy as an aside, in part because they are 2 of the 6 that make up the majority in the Bruin opinion. First, said Justice Kavanaugh, the court's decision does not prohibit states from imposing licensing requirements for carrying a handgun for self-defense. Second, Justice Kavanaugh said, properly interpreted, the Second Amendment allows a variety of gun regulations. Justice Kavanaugh then reiterated the list of presumptively lawful regulations from Heller, including prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms, or prohibitions on dangerous and unusual weapons. The few months following Bruin have been marked by innovation and uncertainty in response to the horrible mass shootings in places like Uvalde, Texas, and a grocery store in Buffalo, New York. The federal government passed the Bipartisan Safer Communities Act, which is the first federal firearms regulation to make it through Congress in decades. In addition, in response to Bruin and the continuing problem of gun violence in our country, New York, New Jersey, California, and other states have passed or are considering firearm regulation. Simultaneously, Bruin has created constitutional vulnerability for laws that had long seemed secure under the old 2-part framework, including restrictions on firearms in the hands of felons, in the hands of those under domestic violence restraining orders, and in places such as hospitals and summer camps. The law is currently in flux, with trial courts coming to different conclusions about the lawfulness of a host of regulations. The axes of divisions between these courts fall into a few categories. Plain text. Does the plain text prong of Bruin's framework mean just contemporary linguistic meaning of people, keep, bear, and arms? Or is it understood as text as informed by history to include categorical exclusions for factors like possession by minors, those with felony convictions or indictments, possession of dangerous and unusual weapons, or activities like manufacturing arms? What is a test if the plain text does not directly cover the activity but simply implicates it? Use of analogs. At step 2 of Bruin, what kind of technological or social change or modern societal problem is sufficient to trigger the more nuanced approach with respect to analogs? For example, are mass shootings a modern societal problem sufficiently different from historical violence to activate this more nuanced approach? What amount of historical regulations over what period of time, distributed across how many jurisdictions, and at what level of generality is required to establish a historical tradition of firearm regulation? For example, there are a number of historical regulations prohibiting firearms in places where people gather for educational purposes. Are there enough historical examples for them to be representative? Are they in the right jurisdictions? Are the regulations relevant for prohibitions on guns in modern facilities like daycare centers or sports stadiums? Kavanaugh's concurrence. How should courts read Justice Kavanaugh's assurances that, properly interpreted, the Second Amendment allows a variety of gun regulations? Do long-standing regulations, such as prohibitions on firearms in the hands of felons and the mentally ill, remain untouched by the Bruin decision? Legislators and litigants are reacting the following ways. Legislating within the bounds of Bruin. Now, some legislators are taking comfort in the fact that Bruin is sufficiently ambiguous with sufficiently open questions that most regulations at least have the potential to be upheld by courts under this new text, history, and tradition approach. Other legislators are using Bruin to justify voting against gun regulations or to vote for expanded gun rights not otherwise required by Bruin. Searching for historical sources and expertise. Lawmakers And those defending regulations, both old and new, realize they must compile a record of historical regulations that can be described as both representative and analogous to the modern regulation. This requires relying on trained historians and on databases of historical materials like the Duke Repository of Historical Firearms Law, and I've got a link in my written remarks. Explaining empirical data within the historical framework of Bruin. Bruin now makes the mere assertion of the importance or effectiveness of a regulation insufficient to render the regulation constitutional. Instead, the regulation must be translated into a historical register. So, for example, whereas once it was sufficient to simply specify certain individuals as posing a risk of violence based on criminological or empirical data, now the data must be tied to a historical tradition of disarming dangerous people. So one may aim to defend a prohibition on arms in the hands of those guilty of domestic violence misdemeanors, not because the founders disarmed those convicted of domestic violence, they did not, but because historically there is a tradition of prohibiting dangerous people from possessing firearms. A domestic violence prohibitor is aimed at dangerous people, and we know that those convicted of domestic violence are dangerous by modern empirical data. Thank you again for the invitation to testify today, and I'm happy to discuss any questions the committee may have about these remarks.
Oh, thank you. Thank you, Mr. Miller. I'm wondering, we were having a discussion before your testimony about the mirroring federal law against defacing serial numbers on a weapon.
Yes.
And so understanding your very clear explanation of the tests involved with Bruin, is it your sense that we are headed to an area of the law where it would be broadly unconstitutional to use serial numbers because they weren't used in the founding days? Or do you think that would fall within the nuanced regulation piece?
So the law is currently in flux. I think the council, the appellate council who first spoke had mentioned the Southern District of West Virginia, who essentially said that prohibiting having a firearm with a defaced serial number is unconstitutional because they didn't stamp weapons with serial numbers regularly at the founding era. But in contrast, the Northern District of Indiana upheld such a regulation in part by saying that the plain text isn't just mere possession. The plain text, the conduct that is asserted to be protected is possession of an unserialized firearm, and unserialized firearms are not in common use by law-abiding citizens. So the best thing that I can say is that, as with everything after the Bruin decision, the law is in flux. We have district courts that are coming to different conclusions at different points in the test as to the constitutionality of serial numbers, and the Supreme Court at some point will resolve this. This is not an issue about the serialized or unserialized nature of firearms that has been directly addressed by the Supreme Court as of yet. I fully expect that we'll see something like that in the next 5 to 7 years.
And then if I could just ask one more question. So it seems to me in looking at Bruin that there's at least potentially a disconnect in the logic that's used. So in terms of weapons that are covered by the Second Amendment, as I understand it, the Bruin decision says that it covers weapons that may not have been imagined in the 18th century. And so in that way, innovation is part of the continuing living protection of the Second Amendment. Whereas when it comes to regulation, regulation is strictly limited by what was imagined in the 18th century or the historical tradition that's provable going forward. Does that seem to you to be at odds, those two pieces, or do you find that it's internally consistent?
Right. I do believe it's inconsistent, and I have written some law review pieces saying that the level of generality needs to operate at the same level on both sides of the rights regulation equation. So, to give a concrete example, in 1791, a trained marksman would have been able to fire a rifle about 4 times a minute. Weapons today range from 10 to sometimes, if you think about bump stocks and other things, 100 times that rate. Now, to say that that is sufficiently analogous to an arm on the right side, that is protected, then implies that we need to think about the same kind of levels of generality about regulations. So of course they're not regulating domestic violence in 1791 because it's just not a crime. It's in fact they just had quite a benighted idea about the relationships, domestic relationships, and the relationships of men to women at that time. But they also had a concept that there were dangerous people that should be disarmed or shouldn't have access to firearms. And so we should be thinking about the level of generality on the regulation side at the same, broad level as we think of it on the rights side. That's my opinion. Some courts are adopting that. Other courts are acting exactly as you say, which is to say that the level of generality on the text prong is very, very broad. Anything that's an arm is presumptively protected, and then requiring very, very close tailoring of historical regulations to the modern regulation, which to me seems unstable to broaden the level of generality at the right side and then to narrow it at the regulation side.
Thank you very much.
For legislators contemplating laws that we think are necessary for Vermont to have, such as a law against straw purchasing that creates a criminal penalty, defacing serial numbers, those things. What is the harm if they are ruled unconstitutional? If we put them in a bill, we make our best effort to follow the decisions of the United States Supreme Court. But it's, as you said, it's uncertain. So obviously, if we put something in that we guess is unconstitutional, that would violate our own oath of office. But I wonder where we're at with provisions like that, provisions like waiting periods, other things that the legislature might consider.
Well, as I said in my testimony, the law is in flux. So, I think that, as you quite rightly pointed out, as long as every legislator is making a decision based on what they think their good faith adherence to the Constitution and what Bruin and the Supreme Court says is required, there actually is still, lots of room. Justice Kavanaugh has told us, properly interpreted, there is plenty of room for regulation. Now, does this mean that there is no litigation risk? No, actually, the litigation risk has been sharply increased. But the test, its application to cases that don't have to do with the kinds of licensing rules that were in New York and California and other states, means that reasonable minds will disagree on what the scope of the Second Amendment is. And I think that legislators in Vermont and other states who take their oath of office to abide by the Constitution of the United States can in good faith vote on things that they think is permitted by Bruin, until such time as the Supreme Court or the courts say that it's that they guessed wrong.
Thank you. That's actually very helpful to me anyway. I don't know about other members.
We have one question from Senator Bohutski.
Thank you so much for being here and for your testimony as we try to make heads or tails of this. In your view, under Bruin, would someone needing to take certain steps like training or a background check or getting insurance on a weapon be before they were able to get one? Would that be in violation? You're not prohibiting anyone. You're simply saying there's some steps that we need before you get there, or waiting periods, or another thing I think I've heard come up.
Well, again, as far as Bruin is concerned, Bruin only had to do with fairly loose guardrails on the discretion that was reposed in granting a license for an unrestricted license to carry a firearm. The court in the Bruin case was quite vociferous of saying, we are not dealing with those states that have what are known as shall issue, where you have to go through a certain set of more concrete objective metrics. So to the extent that the kinds of regulations that you had just mentioned fall within what we might think of a set of more concrete regulations that already exist in some of these shall issue states, both the majority, Justice Alito's concurrence, and the concurrence by Justice Kavanaugh, joined by Chief Justice Roberts, said those are all fine. Now, will there be litigation over them? Certainly. But there is ample language in the opinion that says that, the case is really just dealing with a certain type of licensing rule, and some of these other rules that you've mentioned, the court is not deciding in that case.
Okay, thank you.
If I might ask another, on page 3 of your testimony, say the mechanics of this analogical process is still being worked out in lower courts, but Brown instructs that they're to be guided by how and why regulations burden a law-abiding citizen's right to armed self-defense. So I think they're contemplating that in terms of what we heard earlier regarding not allowing certain people to possess firearms, such as convicted felons, that we're in good stead with that decision. Would that be?
Yeah, I'm sorry, you broke up, Senator, just a little bit.
I'm sorry too.
I think I got the
Yeah.
gravamen of the question. So
the law-abiding citizen
yes.
test.
So the lower courts have been litigating questions about prohibitors that are in the federal regulations and many state regulations, in which you are considering for the state of Vermont, do focus quite expressly on the repeated use of the idea of law-abiding citizens as the relevant group for thinking about who are the people. My personal opinion is it seems implausible to the point of impossibility that the people includes all the people when we're talking about firearms rights. Notwithstanding the fact that, as the counsel for Vermont said before, in cases like Tinker versus Des Moines School District, minor children, 12-year-olds, 11-year-olds have First Amendment rights. It seems inconceivable to me and to 11-year-olds. That said, I think the way that it's been litigated is people that want to essentially oppose firearm prohibitors against felons are saying felons are the people too. They have First Amendment rights. Those that are defending felon prohibitors simply say that again and again, the Supreme Court of the United States in these cases said that the people means law-abiding citizens, not felons. And that's at step one is the axes of the litigation currently.
Thank you. Thank you very much.
Any other questions in here? Senator Sears, do you want us to take a break or move right into the next item?
You're muted, Dick.
Yeah, I try to mute myself in case the dog gets excited. It's up to you. I think a 10-minute break would probably be very helpful for everybody. And then we can move on to the confirmation hearing.
Sounds good.